ಹೋಗೋದಾ ತಗೊಂಡಿದ್ದೀರಾ ಮತ್ತೆ ಯಾಕೆ ಸೆಟಲ್ಮೆಂಟಾ ವೆನ್ ಡು ಯು ವಾಂಟ್ 2:30 ಆಯ್ತು ಕೊಡಿ
Well, it's after 11 years of
ಆಫ್ಟರ್ ವೇಕೇಶನ್ ಬರ್ಲಿ ಅದು
ಆ ಕಡೆಯಿಂದ
ಆಯ್ತು ತಗೊಳ್ಳಿ ನೋಡಿ
well, it's after 11 years.
ಫ್ರೆಶ್ ಮ್ಯಾಟ ಇದೆ.
ಒನ್ ಮಿನಿಟ್ ಜಗದೀಶ್ ದೀಸ್ ಪೋಕ್ಸೋ ಸೆಟಲ್ಮೆಂಟ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ ಕೊಡಿ
My lord, MP MLA court matter.
26
Well, it's after 11 years.
The other accused person, my lord, it is stayed, and some of them are.
ಅಲ್ಲ 26th ತಗೊಳ್ಳೋಣ ಕೊಡಿ
It is an FIR number, my lord. That's the reason I want to. Now,
26th ಅಷ್ಟೊತ್ತಿಗೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ
now, but
Let it come.
nine lakhs-
Well, it's getting
nine
order.
lakhs
Recent for tomorrow, my lord, getting of IA. The interim order, my lord, have filed back.
ವೆಕೇಟಿಂಗ್
The application have filed, my lord.
well, it's after
Things the application have filed, my lord.
ನೀವು ಕೆಲಸ ಮಾಡಿ ಮೆಮೋಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ
well, it's after 11 years of marriage. 3 and 4 of DP Act is invoked. Well,
ಮೆಮೋಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಗಿವ್ ಆಲ್ ದಿ ಮೆಮೋಸ್ ಈಗ ತಗೊಂಡಿಲ್ಲ ಫ್ರೆಶ್ ಮೇಡಮ್ ಎಲ್ಲ ತಗೊಂಡಿಲ್ಲ ಮೆಮೋಸ್ ಮತ್ತೇನಂತ
Lord, this is for tomorrow. Matter, my lord.
Tomorrow.
Identical matter, my lord, is already passed interim orders. Land grab court, my lord. Yeah, MUDA will issue against the farmers. Then tomorrow, my lord, please.
ನೋಡಿ ತಗೊಳ್ಳಿ ಮಾಡಿ
9 lakhs interim maintenance is in arrears. Petition is enjoying a stay on the FLW.
ಗಿವ್ ದಟ್ ಅದು ನಾಳೆಗೆ ಹಾಕಿ
well, it's after 11 years of marriage.
Admission, my lord.
ಸರ್ ಡೂ ಒನ್ ಥಿಂಗ್ ಪ್ಲೀಸ್ ಗಿವ್ ಆಲ್ ದಿ ಮೆಮೋಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ 7 ಇದ್ರೆ ಫಸ್ಟ್ ಬರುತ್ತೆ ಕೊಡಿ
ಇವನಮ್ಮ
ಗಿವ್ ಆಲ್ ದಿ ಮೆಮೋಸ್ ಐ ಕಾಂಟ್ ಕೀಪ್ ಆಸ್ಕಿಂಗ್ ಎವ್ರಿಬಡಿ ನೌ ಗಿವ್ ಆಲ್ ದಿ ಮೆಮೋಸ್
My lord,
ಗಿವ್ ಆಲ್ ದಿ ಮೆಮೋಸ್ ಸರ್
my lord, in this matter, my lord, in SC/ST case, B report filed, my lord. Special court granted stay not to put up construction, my lord.
ವಿಲ್ ಸಿ ಗಿವ್ ಆಲ್ ದಿ ಮೆಮೋಸ್ ಸರ್
ನಾಳೆಗಿದೆ,
ಪ್ಲೀಸ್ ಗಿವ್ ಆಲ್ ದಿ ಮೆಮೋಸ್
ನಾಳೆಗಿದೆ.
ಮೆಮೋ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ
Your order, it was supposed to.
ಗಿವ್ ಆಲ್ ದಿ ಮೆಮೋಸ್
Your lordship.
I am not going to take individual memos. If you want individual memos to be taken, come at 2:30.
Please.
Please come at 2:30. If you want any mentioning to be made, please come at 2:30.
ಇದು
ಅದು 2:15 ಬನ್ನಿ ಸರ್
ಲಿಸ್ಟ್ ಆಗ್ತಾ ಬೋರ್ಡ್
2:15 ಬನ್ನಿ ಸರ್ ಇವತ್ತು 2:15 ಬನ್ನಿ ಅವಾಗ ಹೇಳಿ ಏನು ಅಂತ ಸೆಟಲ್ಮೆಂಟ್ ಯಾವತ್ತಿಗೆ ಬೇಕು ಆಯ್ತು ತಗೊಳ್ಳಿ ಪ್ಲೀಸ್ ಕಮ್ at 2:30. I'll hear all of you and take because not much of time. Yes.
Market. How you are going to exit?
2:30 ಬನ್ನಿ ಸರ್ ಯಾಕೆ ಕಷ್ಟನಾ ಅನೌನ್ಸ್ಮೆಂಟ್
Section 180.
2:30 ಮೇಡಮ್ ಪ್ಲೀಸ್ ಕಮ್ at 2:30. Pronouncement.
It's number 1, pronouncement of order.
Silence, please. I'll read the summary of findings. The complainants were justified in registering the complaint or seeking approval at the hands of the governor. The approval under section 17A of the PC Act is mandatory in the fact situation. Section 17A nowhere requires a police officer to seek approval in a private complaint registered under section 200 or 223 of the BNSS against a public servant for offences punishable under the provisions of the Act. It is the duty of the complainant to seek such approval. The governor in the normal circumstance has to act on the aid and advice of the Council of Ministers as obtaining under Article 163 of the Constitution of India, but can take an independent decision in exceptional circumstances and in the present case projects one such exception. No fault can be found with the governor exercising independent discretion to pass the impugned order. It would suffice if the reasons are recorded in the file of the decision-making authority, particularly of the high office, and though those reasons succinctly form part of the impugned order, a caveat, reasons must be in the file. Reasons for the first time cannot be brought before the Constitutional Court by way of objections. The gubernatorial order nowhere suffers from want of application of mind. It is not a case of not even a semblance of application of mind by the governor, but abundance of application of mind. Grant of an opportunity of hearing prior to the approval under section 17A is not mandatory. If the authority chooses to do so, it is open to it. The decision of the governor of alleged hot haste has not vitiated the order. The order is read to be restrictive to an approval under section 17A of the Act and not an order granting sanction under 218 of the BNSS. In the facts narrated in the petition would undoubtedly require investigation. In the teeth of the fact, the beneficiary of all these acts is not anybody outside, but the family of the petitioner. The petition stands dismissed.
But grateful to your lordship. It was indeed privilege assisting your lordship.
So to hear Singhvi sir and you, everybody sir, it was a privilege.
No, it was indeed a privilege, my lord, to assist your lordship.
Dr. Singhvi Malad wants to make a submission.
Yes, sir. You're not audible, sir.
Continue now. Well, as the matter relates to dates of 1990s, and well, the complaint is filed now, and your lordship had a stay operating. Can your lordships consider a 2-week stay on this? Well, still everybody takes appellate
No, sir,
recourse.
I can't stay my own order, but I can definitely assure before 2:30 it will be uploaded and it is on the first floor.
Please.
Since well, there was a stay operating in my favor,
That's all right,
and the
sir.
complaint is filed in.
No, sir, I have said so. 1 minute, that also I will read. Petition dismissed, interim
Very well.
order of any kind subsisting today shall stand dissolved.
Great.
Very well.
Right, your lord.
Yes.
Lords, I may be permitted to take. My lords, I may be permitted to take the original file, my lords, of our governors.
Who appears for the office of the governor? Sir,
Yes, my lord.
Solicitor General, sir.
Yes,
This
my lord.
original file of the governor, I am returning to your advocate on record.
Please,
I'm grateful to your lordship.
Yeah.
please,
Whoever is it, ಅದಕ್ಕೆ ಮೇಡಮ್ ಕೊಟ್ಬಿಟ್ಟು
oblige.
Obliged.
ಮೇಡಮ್ ಅದು Yes. ಇದ್ದಾರೆ ಅಟಾರ್ನಿ ಜನರಲ್ ಎಲ್ಲಿದ್ದಾರೆ ಬರ್ತೀನಿ ಒಂದು ನಿಮಿಷ ಡಿ ಎಸ್ ಜಿ ಅವರೇ ದಟ್ ಅಟಾರ್ನಿ ಜನರಲ್ಸ್ ಮ್ಯಾಟರ್ ಕೆನ್ ಐ ಟೇಕ್ ಇಟ್ ಎಟ್ 2:30 ಇಫ್ ಇಸ್ ನಾಟ್ ಎ ಪ್ರಾಬ್ಲಮ್ ಫಾರ್ ಹಿಮ್ ಆಲ್ ರೈಟ್ ದೆನ್ ಆಲ್ ರೈಟ್ ಎಸ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರಿದ್ದಾರೆ ಎಸ್ ಎಸ್ ಕರೆದು ಬಿಡಿ
Number 2, field number 1.
I'll start with the list then. Jodi sir, I'll start with the list. When it comes, you tell me. Yes. I'll be taking the first list. Yes. Everybody. First list ಕರಿತಾ ಇದ್ದೀನಿ. ಕರ್ದ್ಬಿಡಿ. He's not yet come. ಕರ್ದ್ಬಿಡಿ. After he comes, I'll take it. Yes. Take it. Call the first list. Sir, ಅವ್ರು Professor sir, ಅವ್ರು ಬಂದ್ಬಿಡ್ಲಿ.
List one, fresh matters, till number 2.
In the meantime, next. Next.
Number 3.
Same. State, sir. Yes. ನಿಮ್ದು ಅಷ್ಟೇ ರಮೇಶ್. ಕಾವ್ಯ ಪ್ರೋಟೋಕಾಲ್ ಗೊತ್ತಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು. ನೋಡ್ಕೊಂಡಿರೋ. Page 29, sir. No way for interim order. Take chance after vacation. ಇಲ್ಲ ಕೊಡೋದ್ರೆ ನಾನೇ ಕೊಡ್ತೇನೆ. All the family members. Correct. Page 29 ನೋಡಿ. No false case. ಫಿರ್ಯಾದಾರರ ಮೇಲೆ ದೊಣ್ಣೆ, ಕಲ್ಲು ಮತ್ತು ಕೈಗಳಿಂದ ಹೊಡೆದು will list it after vacation. List after vacation. Yes. Will not dismiss it. Continue ಆಗ್ಬಿಟ್ರೆ ನಾನು ನಿಮಗೆ ಕಷ್ಟ. ಚೇಂಜ್ ಆದ್ರೆ ತೊಂದರೆ.
5.
Yes. ಕಾವ್ಯ A2, A3, A4 ಕಾಶ್ಕಾನ್. Respondent. A learned counsel so and so undertakes to enter. ಯಾವುದು serial number?
5, madam.
First list.
Yes, madam.
Ajit.
Second list, sorry, madam.
A1, A2, A3 ಕಾಶ್ಕಾನ್. Sorry, ಅಲ್ಲ A2, A3, A4 ಕಾಶ್ಕಾನ್. Next.
Number
2 to 4,
6.
madam.
Arun Kumar. 2013 CC. I will not interfere now. Huh? No. 11 ವರ್ಷ ಆದ್ಮೇಲೆ I will not interfere in a 482. The subject petition, the petitioner is before this court now seeking the following prayer. The crime is of the year 2012 and the CC of the year 2013. 11 years have passed by. The petitioner is now knocking at the doors of this court, contending that the crime so registered and the charge sheet so filed after the registration of the crime are all an abuse of the process of the law. There is no ground made out for interference at this juncture, more so in the light of the fact that the matter is pending before the concerned court for the last 11 years. If the submission is that the trial has not yet commenced, the trial court shall endeavor to conclude the proceedings with an outer limit of 6 months, if not earlier. Next. Ordered accordingly.
Disabilities, children's benefits have been eaten away by these people.
What impossible to stay.
Yes,
Yes.
7, 8 and 7.
List after no representation, list after 4 weeks. Not to list the matter prior to the expiry of 4 weeks. Next.
Number 7, Your Lordship, I am asking for petitioner.
I have not yet come to 12. Wait, sir.
8.
Same, 8. 4 weeks. Yes. Nishant, in the meantime, next.
ಅಲ್ಲ ಇದರಲ್ಲಿ issue my lord, they are taking section 5 of the act. Section 5 of the act has no applicable.
ಯಾವ್ದು serial number 9 ಅಲ್ಲ?
Yes, my lord.
ಕೊಡಿ. Identical matter stay ಕೊಟ್ಟಿದ್ದೀವಿ ಕೊಡಿ.
ಅಲ್ಲ ಅದು that exorbitant interest rate.
ಹಾಗಾದ್ರೆ Thursday ಆಗ್ತೇನೆ in the fresh matters list. Tag this petition along with criminal petition 4037 of 24.
None.
List them both.
Sorry, not this matter.
What?
Next
sir?
matter.
ನಾನು ಓದಿರೋದ್ಮೇಲೆ ನಂಗೆ ಡೌಟ್ ಬಂದ್ಬಿಡುತ್ತೆ.
Sorry,
In the mean, tag this petition in the meantime. Yes.
this matter, my lord.
ಇದ್ರಲ್ಲಿ
Yes.
ಇದೆ ಹೇಳಿ ಕರೆಕ್ಟ್.
Yes.
ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 4 weeks. ನಿಶಾಂತ್ಗೆ ಗಾಬರಿ ಮಾಡ್ಬಿಟ್ರಿ. In the meantime. You will just stop at 12. We'll hear the Attorney General and then get back. Yes, sir. No, by the time you came, I finished 12 cases.
One of the virtues of virtual hearing is that we can travel to many places trying to finish a case.
Yes, sir.
The pleadings are now complete.
ಅದು ಫೈಲ್ ಕೊಡಿ. ಇದೆನಾ?
Counter affidavit and our.
Kindly permit me to pass the memo notes where senior Acharya has been appointed as the state public prosecutor.
Fine. Yes.
Memo with the
All right. Senior. Sir, Professor, sir,
Corporation.
both of you.
Corporation.
Oh, sorry.
I am for the sixth response.
All right.
It's very interesting and to see my
Lord.
learned friend here.
The lordship's kindly.
Please go ahead.
Lord, I'm appearing for respondent number 1, my lord.
Oh, government.
Respondent number 1.
Other state.
State.
Yes, sir.
My lord, I would like to raise a preliminary objection, my lord, with regard to the maintainability of the writ petition.
All right.
Because after the filing of the writ petition, my lord, there are two developments. One is the judgment of the Supreme Court in the state of West Bengal versus Union of India. And other in my lord is the division bench ruling of this honorable court following that judgment, my lord, which in effect has dealt with the power of the CBI, interpretation of the provisions of the Delhi Police Establishment Act, etc.
I mean, matter that was sent to the Supreme Court.
Yes.
Please, my lord, yes. So that question is there, my lord. This is virtually a dispute between the state and the union
Not at
with
all.
regard to the right to
Not at all.
investigate. Please,
I don't agree with that.
please, ma'am.
It is not a dispute between the state and the union. It is a dispute with regard to an individual or the corporation that is said to have siphoned off the funds or whatever it is, misappropriation of funds. And the Union Bank of India is here wanting it to be referred to the CBI. That is all. Where is the state and the center dispute in this?
No, my lord, here the question is, the writ petition relies upon the circulars issued by the central government, which in effect, my lord, that is the foundation of the prayer in the writ petition. And the question is whether such circulars can interfere with the power of the state government, my lord, and the state police.
I will answer that on merits.
Please, madam.
I will answer that on merits.
Please.
But I will not hold that it is a dispute between the state and the center.
No, my lord, kindly, similar, of course, subject to the identical question was argued in the, before the Supreme Court. The state union took up the preliminary objection, my lord. It is only a dispute between the
West
CBI
in the
and
West
the
Bengal
West Bengal state.
In the West Bengal case.
Yes. Dispute is, that was the specific,
No, if apex court has held so, then we will be bound by it. Let's see.
no, that is why, my lord.
But
Only-
division bench definitely bound by, but if there is something, if it is between the center and the state.
Yes.
if
No,
that
my
is the
lord.
issue-
Before in the West Bengal case, my lord, the question was with reference to the power of the CBI to further investigate into cases in West Bengal where the state government has withdrawn consent. And
Consent,
the-
whichever.
and the specific objection of the Union of India in the case was that suit was filed by the state, my lord, state of West Bengal. Union of India contended, raised a preliminary objection. The suit was filed under Article 131. The contention of the union was that 31 is applicable only if the dispute is between union and the state, not between the state and the CBI. Now, that was answered by the Supreme Court, my lord. It rejected the contention of the union that CBI is a different entity. But the Supreme Court went into the details and held that it is under the supervision of the central government, and in effect, it is a dispute between union and the state.
Supreme Court has answered that it is a dispute between union and the state and only the apex court has to decide it. Is that the finding of the apex?
Yes, and it overruled the objection of the union and said the suit is ordered to be, may I just pass on that to you.
Attorney General, sir. Since he's on maintainability, I'll just look into that judgment and get back. Yes. Paragraph, sir.
I thought we must be having an. Para 2, my lord. On filing of the suit, preliminary objections have been raised by the Defendant Union of India with regard to the maintainability of the present suit. Though the judgment, through this judgment, we have dealt with the contention of the parties on the aspect of maintainability. Because, my lord, Article 131 says the jurisdiction of all other courts are barred, where the dispute
Yes.
between the union and the.
And the state, correct.
Now, para 4 onwards, my lord, the objection of the union saying that it is only a dispute between the CBI and the state of West Bengal, not. While the plaintiff submitted that CBI is directly under the control of the union, and therefore it virtually amounts to a dispute between the union and the state.
Yes, sir. This may require an answer. Yes, sir. Same, sir. Right. No, I was not aware of this. Yes.
I relied on two more authorities.
We'll decide about the maintainability first
Also, I raised the question of locus.
of the Union Bank of India.
Bank. To file a petition, using a investigator.
Yes.
So they have to respond.
Yes, sir. We'll cross the threshold bar
Of course,
of maintainable.
we need to do that.
Yes.
I have no difficulty in addressing that question. The writ petition is premised on a principle which does not lie within the domain of the Delhi Special Police Establishment Act at all.
Yes.
Both the state of West Bengal judgment and the judgment enters a field where the DSP Act governs and what should be the regime. This is the fallout of the Delhi West Bengal judgment, the constitution bench judgment. It doesn't lay down any new principle as regards. Since the question of maintainability of a suit was raised, the court has to answer that. Again, within the framework of the DSP Act. The controversies were within the framework of the DSP Act. Once, if the court is able to see and is persuaded, if I am rightly persuading, that we are not in the domain of a DSP Act at all, then the question of maintainability, taking recourse judgments, I think will be misconceived. So why do I say it does not fall within the scope of the DSP Act? The DSP Act is of 1940. The Banking Regulation Act came in 1949. Much later, Section 35A come much little later. Before I go into the relevance of Section 35A and why the Reserve Bank of India as the custodian of the integrity of banking transactions under the Banking Regulation Act and also on the RBI Act, before I get into that. If there is a special legislation to deal with the functions, activities, supervisory regulations, etc. of a banking entity, then in due course of time when RBI finds and that the bank frauds now require a special attention, then Section 35A comes in. Under the authority of Section 35A, Reserve Bank of India issues a master circular. That authority of the Reserve Bank of India to act under Section 35A is neither regulated, conditioned, or qualified by the DSP Act at all. The DSP Act contemplates when offences within the territorial jurisdiction of a state are committed, where by reason of the federal dispositions, the state investigation authority will have the primary duty responsibility to investigate and prosecute. The central government can still come in. So a special allowance is given by Parliament to the central government to come in and say, look here, I would like to investigate with an agency which is specially created under this special law. So would that be a matter of propriety for the central government to issue a notification under Section 5, having regard to determination under Section 3 of the DSP Act, that I would do it unilaterally? Therefore, the Delhi Special Police Establishment says you would not do it unilaterally. We have a federal structure for good reasons. The state government will come and say, yes, I give my consent. So it is a matter of high level of understanding between the central and the state government, where the state government will ordinarily yield to a central government's understanding of the need, importance, and relevance of the CBI undertaking an investigation for a variety of factors. Will ordinarily yield, because there is no conflict or hostility between central and state government in this regard. It is the understanding of both the governments works at a certain level of responsibility and transfer of, therefore they will ordinarily yield. But there are circumstances when the state may say, what is great about CBI to come into this matter? And therefore, we have our public order, law and order, administration of justice. If they are state subject, we are competent to enter into the investigation and prosecute them. That's how the DSP Act will have to work, and it has worked for a long time. Consents are being given. But when, for other reasons which are not entirely legal, if state and central governments begin to have differences of views on giving consent, so we enter into a very new stage of federal disagreements. Whether they are good or bad is a different question. We are not arguing that question today before the court. So since central government will notify that, let's kindly turn to the DSP Act for a minute.
Delhi Special Police Establishment.
Delhi Special Police Establishment Act.
Banu Prakash
But the Act contemplates setting up a special police force. Now kindly turn to section 3. The central government may by notification in the official gazette specify the offences or class of offences which are to be investigated by the Delhi Special Police Establishment. Then comes section 5. The central government may by order extend to any area. Once it has notified that under section 3, that central government may by order extend to any area, including railway areas in a state not being union territory, the powers and jurisdictions of members of the Delhi Special Police Establishment for the investigation of any offences or class of offences specified in notification under section 3. When so-and-so is notified, said police establishment extend to any such area, a member thereof may subject to any orders which the central government may make it on his behalf, discharge the functions of police officer in that area, and shall while so discharging such functions be deemed to be a member of the police force of that area and all that. Now, kindly turn to then section 6.
Consent.
Yes. Nothing contained in section 5 shall be deemed to enable any member of the Delhi Special so-and-so to exercise the powers and jurisdictions in any area, not being its etc., without the consent of the government of that state. So if you keep aside this act for a minute and look into the Banking Regulation Act and section 35A,
A.
yes.
Yes.
This act, of course, has gone through large number of revisions, amendments, and so on and so forth. But if the original statement of objects and reasons, which are contained in 2 or 3 paragraphs, Lordship will permit me to quickly read them. Because unlike what happened in the
Power to issue directions.
that's true. I'll just come to that.
Banking.
I'll just come.
Yes.
I'll just come. If the why is 35A conceived at all?
Yes.
If 35A is conceived that in the public interest or in the interest of banking policy, or to prevent the affairs of any banking company being conducted in a manner detrimental to the interest of the depositors or in a manner prejudicial to the interest of the banking company, or to secure so-and-so, etc., necessary to issue direction to banking companies generally, banking companies in particular, to issue such direction to banking companies or the banking company shall be bound to comply with directions. Now, these are very words of wide import. Now, today, a banking institution, unlike the early parts of the history of banking institution, occupies the core of the economic and fiscal discipline of a country. So anything which impedes such fiscal discipline or may have an impact on the fiscal discipline, the discipline of banking industry, has a large, wide range of implications for the entire finance and economic transactions. A dent here, a hole here, something happens somewhere with the banking industry means it may have large implications. Therefore, 35A comes in, and the RBI says, I will issue all kinds of directions possible to ensure the integrity of the banking functions and the integrity of a bank as a public entity. Where a bank is not merely now a person who receives a deposit and then gives some interest and gives it back. So it discharges a wide range of functions. So it discharges function relation to development of the economy, etc. If that is the position, if Reserve Bank of India issues a master circular in exercise of its power, and it sees that in order to ensure that the integrity of banking function will lie within my domain under 35A, it doesn't have to go to any other authority, including a central government, to seek assistance, solicit opinions, views as to how I will instruct banks to act in terms of my directives. So when these directives are issued, what do they intend to achieve? I'll take your lordship to the directions in a while. So if looking at it objectively, if there are 2 ways of looking at this 35A, one is to read it as expansively as possible to ensure that in the interest of all these matters which I just now talked about, the economic and fiscal discipline and the role banks play today in entire economic activities of the nation, if they have to be read expansively. And RBI says, I would probably conceive that a specialized agency would be the best suited agency to look into any offenses, either in relation to the banks or committed through the instrumentality of the banks, either by officers of the banks, with or without connivance, or an entire set of outsiders who use the bank as a tool or instrumentality for committing certain set of offenses.
One clarification.
Yes, Your Lord.
Which is the bank in the respondents involved in the case? For RBI to direct, the particular banking institution should function with integrity or it has crossed the limits and other things. Which is the bank involved here in the state of Karnataka?
Union Bank.
Union, that's the petitioner.
That's right.
Huh.
Let me
If the Union Bank itself is.
let me try to
Yes,
develop an argument.
Yes.
That's why when I looked at 35A, I could look at it very narrowly. It is a set of indoor directions for the banks. You can read it like that. But I don't think that should be read such restrictively and narrowly. They are not meant to occupy a mere indoor direction to the banks at all. So if therefore Reserve Bank of India conceived a larger role to be played by it in ensuring that the integrity of the banking system, and in particular any particular bank, have to be so directed, supervised and monitored and regulated, and it issues a direction, I suppose just as 35A will have to be read expansively, the directions issued by the bank also will have to be read relevantly and expansively. So I'm not looking at an offense committed by an officer of the bank along with somebody outside the bank. Because there can be a wide range of ways today in which bank as a banking entity can either become a victim, can either become a tool, or can become a player in the field where offenses could have been committed. I'm not concerned with what class of offenses are being committed. I think for the purpose of 35A and the Master Circular, the focus is not on what kind of offenses. The focus is on ensuring that whatever be the offenses committed, the integrity of banking industry, integrity of banking transaction must be ensured and guaranteed. So today a wide range of offenses where banks come into play. PMLA Act also is involved in many circumstances. Therefore, the kind of transactions which a person through monetary transaction, we have cryptocurrency. So we have all kinds of things which happen which through technology can defy very conservative notions of banking functions, etc. Therefore, if we take a larger view of what the Reserve Bank of India thought should be done, it then designates in exercise of its authority under Section 35A, saying that CBI would be the investigating agency for looking into offenses which relate to banking transactions. I'll go through the Master Circular in a while. In order to therefore either to issue a Master Circular under Section 35A or issue guideline directions of any nature whatsoever, because the RBI has given a wide authority under this. You can give it any designation or name. It hardly matters. The power is available, then what it does will only matter. Therefore, the Master Circular says that CBI will be designated as the only authority to investigate certain class of offences. For doing that, does the RBI require to go to central government? The RBI does not require to go to central government at all. And what the RBI does under these provisions, including a Master Circular, will not again fall into the domain of a central government to act under Section 3 and 5 of the Delhi Special Police Establishment Act. They operate in distinct parallel fields. So a certain class of offences, a certain set of entities and establishments in respect of which the framework of law is entirely different and therefore falls within the special legislation. Delhi Special Police Establishment is kept out. If 35A or is there any provision enacted under the Banking Regulation Act, including the Master Circular that would have been issued by the Reserve Bank of India, which said, I require the consent of central government, and central government alone will determine whether CBI can go and investigate at all, then the RBI could have done that. But RBI, in all its wisdom, having a regard to the width of the power available under 35A, I said, no, I don't require that recourse at all. I don't require the assistance of central government to ask CBI to investigate. No, kindly look into the master circular. Therefore, the two legislations operate in parallel fields. Delhi Special Police Establishment does not condition, qualify, or limit the Banking Regulation Act in any manner whatsoever. We are not concerned with certain offences where, like any IPC offences, which may not have a concern with a particular entity or an establishment, which have implications for the economic and fiscal discipline of a country. We're not really talking about mere forgery or conspiracy or collusions, etc. They will be offences. But they are offences committed using bank as a tool or an instrument. Now, I ask myself a question. If the corporation which has laid a complaint against the managing director and the executive director of the bank early in point of time, the chairman of the corporation lodges an FIR. And he says the managing director and the ED are involved in these offences. A very ingeniously manufactured FIR. And then now it knows that the charge sheet shows that the author of the FIR himself is an accused. So I look at it like, why did it travel like that? They could have straight away said, neither the MD nor the ED, but some officer of the bank is involved. We also find some outsiders who had used the bank as an instrument or a tool for committing offences. The corporation could have come clean with an FIR which is of a highly respectable nature. The corporation did not do so. Which means I gather, or any independent observer would gather, that the lodging of the FIR by the head of the institution, the corporation, was with malafide intentions. I'll try to expand that. But I'm not going to put my stand heavily on that. Therefore, every strand of the certain events in this happened will have certain connections. So as far as I'm concerned, if I am right in saying 35A and the Master Circular are under a statutory framework which are not conditioned or qualified or limited by the Delhi Special Police Establishment Act in any manner of consumption. So let's request a lot to look at the Master Circular at this point of time. Page 153. 64. Huh? 53.
156 it starts.
So now the bank has registered a complaint that is at Annexure A.
That's right.
Now you are asking this complaint to be investigated by the CBI.
Because under the Master Circular, the CBI is the only investigating agency.
No,
it is not that there is a small mix-up in the play.
This is concerning a corporation.
Yeah.
There is no other bank. Is any bank involved in this? Except Union Bank of India is involved in this.
We don't know. We don't know.
Because it is a state-owned corporation. And Union Bank of India is complaining, has registered a complaint against a state-owned corporation.
Some money that gone to Hyderabad and some other places. So what banking transaction, which banks are involved, how that is a matter for a later day consideration. But the Annexure H, Annexure A.
Yes. Annexure?
One. Let me first read the Annexure A is a complaint by the bank.
Yes.
He talks about all that events in relation to the FIR and how the bank has been subjected to so and so.
Yes.
And at page immediately after subparagraph 5, it says, "Hence, to ensure a free and fair investigation, we request you to transfer so and so to CBI."
Yes.
Now, there is no estoppel in making such a
Subject
statement.
to correction, Annexure A, my lord, is a representation, not the complaint, my lord.
Or to the Additional Chief Secretary. Yes. Hence, ensure a free and fair investigation. Request you to transfer. It is a representation.
That's right.
It is dated 19th.
It is.
6, my lord.
Soon after.
And this writ
soon
petition
after
is
the
filed
bank
on
came to-
21/6,
All right.
2 days.
After the bank came to know about what has happened.
The FIR is in page 115, my lord.
I'll come to the,
Their complaint is against the 3 officials of the bank.
come to the FIR. The FIR was lodged by somebody else. We did not lodge an FIR. Now let us go on this footing that the banks makes a request to the government on a certain understanding that is a matter for CBI. So suppose there is no master circular. Suppose there is no 35A at all. How would I look at this letter written by the bank to the government of Karnataka? How would I look at it? So in the light of section 35A and the master circular and my submission, that since the field is already assigned to and occupied by CBI under a certain framework of law, this request does not make any difference whatsoever. This letter cannot be read to mean that regardless of 35A and the master circular, you are now getting into the shoes of the central government under sections 5 and asking the state government to give its consent or a transfer. I think there is certain misconception about this letter, and therefore I say this letter does not really the final word on the law on the subject. So kindly now turn over to the master circular for a minute.
Yes, sir.
Before that, can I request the Lordship to kindly turn to page 135. 135.
135, sir.
Yeah, it's a letter written by the bank to CBI. So this is virtually a lodging of a complaint with CBI. So the entirety of the events relating to this matter have been set out. And at page 144, I don't need to tell you lots of the details of all that.
Yes.
Page 144, at the bottom of the tabular statement, based on the above facts and circumstances, we are of the firm opinion that the above allegations are acts of crime. Hereby affirm that no other complaint has been filed by the bank with any other law enforcement agency. Also intimate that no orders of the court or operation which limit the bank from lodging the complaint and initiating the criminal investigation. Therefore, request to conduct detailed investigation, etc. Then the competent authority, the Union Bank of India, issued prior approval under section 17A, and the same are enclosed with this complaint. This complaint is being filed with the request, take it on file, register FIR, investigate, apprehend and book the culprits involved, take action in accordance with the provisions of law against so-and-so, causing wrongful loss to the bank and wrongful gain to themselves, and thereby committing the various offenses, namely all that.
Now CBI is investigating into this, into this
The
complaint?
CBI has taken it on record.
All right.
Now kindly,
3624.
all right. Now kindly come to page 153, and we have the master circular, which begins at page 1. Let me just quickly take your lordship to page 154.
Yes,
The
sir.
contents of these circulars.
Yes.
So we have chapter 3 called the Central Fraud Register, reporting of fraud to the Reserve Bank of India. Then chapter 4, reports to the board, quarterly review on frauds, annual review of frauds, and special committees of the board, and cases of attempted fraud, etc. Then chapter 5, closure of fraud cases. Therefore, this set of directions are a complete code in themselves.
Yes, sir.
Complete code in themselves. Now come to chapter 2, classification of frauds at page 157.
Yes.
These are, in my understanding, are illustrative. Then turning over to page 158, chapter 3, a central fraud 3.1, a central fraud registry based on the fraud monitoring returns filed by the banks and the select so-and-so, including update thereof, has been made available, for which banks have been given access through user IDs and password, etc. The practice of issuing paper-based, all that is right. So we have a central fraud registry. Then 3.2, banks need to furnish fraud monitoring return in individual fraud cases, irrespective of the amount involved, by using and all that. Now, also, page 159, 3.2.3, fraud reports should also be submitted in cases where central investigating agencies have initiated criminal proceeding so moto and where the Reserve Bank has directed that cases be reported as frauds. Banks may also report frauds perpetrated in their subsidiaries, affidavits, joint ventures, so etc. So therefore, we have, and page same page 3.2.7, for the banks are also required to furnish developments in the fraud cases through update applications applied. Then kindly turn over to 161, reports to the board, to the RBI. Banks should ensure that all frauds are reported to their boards promptly on their detection. Such reports should, among other things, take note of the failure on the part by the concerned branch officials and controlling authorities and give details of actions initiated against the official responsible for the fraud. Then there's a quarterly review, then the annual review of frauds. Then turning over to page 163, the importance of looking at banking frauds is, I think, is set out here in good measure. So we have 4.4 special committee of the board. Well, audit committee shall monitor all the cases of frauds in general. Banks are required to constitute a special committee of the board for monitoring and follow-up cases of frauds involving amounts 10 million exclusively. The special committee is to be constituted 5 members. So that's another detail of how the special committee will work. Then closure of fraud cases, kindly turn over to chapter 6 and particularly at page 167. In dealing with cases of fraud, embezzlement, banks should not merely be actuated by the necessity of recovering expeditiously amount involved. I stop here for a minute because one of the statements made in the charge sheet or otherwise is, oh, we have recovered about good part of the money. So, but should also be motivated by public interest and the need for ensuring that the guilty persons do not go unpunished. Therefore, as a general rule, the following cases should invariably be referred to the state police or to the CBI as detailed below. So in private sector, foreign banks, category of banks, then you column 2, amount involved in the fraud, 10,000 above, 1 million above, all that is state police, if committed by staff, here the remarks, and 1 million above, state police, if committed by outsiders, on their own, and with the connivance of bank staff officer. And 10 million and above, in addition to state police, serious fraud investigating office, Ministry of Corporate Affairs, Government of India, second to so-and-so, then remarks, details of the fraud ought to be reported to the SFIO in FIR format. Then public sector banks, below 30 million, 10,000 and above, but below so-and-so, state police, then we have remark committed by itself, then we are looking at the third part of it, 30 million and above, and up to 250 million CBI, to be lodged with the anti-corruption view of the CBI in so-and-so and made so-and-so. Economic offences wing, more than 250 million with the banking security and fraud cell of CBI, and more than 500 million to be lodged with the joint director CBI headquarters. Having regard to the quantum, the hierarchy within the CBI will also is also changed. Therefore, this is a principle as a part of the master directions issued by the bank, by the RBI, is binding on the bank. If it's binding on the bank, it says, I have no other option but to go to CBI. I don't go and request anybody else say, I need your consent. So inbuilt in this very scheme of, as I said, 35A and this master circular, that this scheme is completely outside the domain of the Delhi Special Police Establishment Act. For a very, very important reason. The important reason is, as I said right to begin at the beginning, the banking industry, the importance of ensuring the integrity of banking industry And if the parliament thought 35A should be probably narrowly tailored, why can't state investigation agencies look into banking industry frauds? Well, the parliament could have done something differently.
No, state government does not.
Pardon?
State government does not look into the banking frauds of the ones.
That's why the mass circular says that within a certain limit, state police will do it. But the
Now-
moment the limit goes up,
Limit goes up, it has to go to the CBI.
we have gone beyond that limit.
Now you've gone beyond that limit, definitely.
right.
Now a crime is registered in crime number 118 of 2024 against banking officials.
Yes.
I believe those are all dropped while filing the charge sheet. So no banking official is there as on today as an accused in any crime. And in the crime that you have registered before the CBI, that is against those banking officials, the CBI is going on with that.
No, I look at it slightly differently. I'm a little concerned. I am not here as a.
Sorry, but I just wanted clarification.
sorry.
No, sorry, sir, but I wanted clarification, so I have taken it.
Yes. I just come back to it. I understand the nature of the dimension of the issues.
Yes.
And I also stand here not taking any partisan stand. I try to understand why RBI says that I will be the master of any banking fraud. But then if it's a very small amount, I don't need to worry about it. If that is so, then there is no other process or a procedure which can be conceived where somebody else, including a state government, will come and say, I have done an investigation regardless of the quantum of the fraud involved. Now, we began an investigation on an FIR given by somebody who turns out to be an accused himself later, and the banking officials, we've exonerated them now. The FIR lodged by the chairman of the corporation was with very strong understanding of the fraud involved by the conspiracy or the banking official. Now, I will find a way out. The investigating agency can look at it saying, I will find a way out. CBI need not come in. I will exonerate all the bank officers now. Let them out at this point of time. Why should the state government then think, oh, the officers of the bank are out? CBI will also therefore be shown the exit doors. So you are, in a manner of speaking, done your investigation having regard to the implications which have emerged in the public domain. You thought this is the best way of going about shutting out CBI entering into the picture. Am I arguing canvassing a case where if CBI comes, they will probably bring in the banking officials also in the net? May or may not be, I do not know. I am not speaking here on behalf of the bank as concerned about the officers also. If suppose the executive director and managing director involved, so be it. So, but that can happen only if an agency which is exclusively given the authority to investigate does the investigation. I mean, that means not only that. I don't want to travel into certain domains which will look very controversial and may also look maybe a little difficult to travel. I'm traveling this very, very cautiously. I mean, very. So anything the attorney says will be part of a public debate. So I'm very careful about that.
Yes.
But I try to look at it objectively as possible. One understands that in many of these transactions today in public affairs, public life, it's very difficult to draw a line somewhere and say, objectively speaking, this is true. And even if, and as one of the American historians said, objectivity is not necessarily neutrality. So therefore, the truth in public life today, many things happen. Many people, accountability, transparency, wrongs, errors. So they get mingled in the hailstorm of politics and then so, but given that all that position and picture, I only thought that if RBI way back in 2016, when perhaps the current set of affairs where all this get mingled, probably were not there. Banking fraud going back to the old Mundra case, all the days onwards. The banking frauds were, of course, even then involved public, people in public life. Krishnamacharyas, all those, you'll have to remember that. But that was a slightly different issue altogether. Today, it is assuming all kinds of, like the octopus spreading its tentacles. If I am not wrong in using that. So the tentacles reach where we do not know. So if that is so, it's important that this law, that the Banking Regulation Act and the RBI authority go untrammeled. And therefore, I ask myself a question. If that is so, and if state government will come in only under Section 5 of the DSP Act, a very responsible state government will say, I have nothing to do with this matter. If CBI is the person to go under this law, and let it be. But if the state government says, no, I have something to do with this matter. I want to oppose CBI because I have power under Section 6. I have a sense of discomfort about that. The sense of discomfort is not again in any political sense, I mean the legal sense. In the legal sense, there is a sense of discomfort. Therefore, my submission is CBI will necessarily investigate this matter. It may reach the same conclusion as the conclusion with the state police have arrived at. It may reach yet another different set of conclusions where who will be involved and not, nobody knows about it. Perhaps CBI may even drop the investigation. We do not know. So to thwart or to at the threshold to say, Mr. CBI, you are an alien to this issue, I think is something to be questioned. I think something to be taken very, very carefully with a pinch of salt. So I don't think this judgment of just Supreme Court in the context of a maintainability of a suit and in the framework of Delhi Special Police judgment will have any relevance on that.
So that is one thing, sir. The other thing is the learned senior counsel is saying, you cannot choose the investigator. Now you fall back upon 35A even for that.
No, that principle is a broader principle in criminal jurisprudence.
No,
right?
only
I cannot. In the broader criminal jurisprudence, because long ago in Hobbes Leviathan said, look here, I'm taking over authority. The state will take over authority to do what it wants to in matters of doing justice. So I cannot do a private wrong. If I cannot do a private wrong by choosing an investigator who will probably shield and cover my wrongs. So that is the principle where that it comes in. But the bank is not choosing. If the bank says, I don't want CBA, I don't want state, I will want somebody else, I can understand that. It is not in administration of criminal justice, this principle is equivalent to a forum shopping principle. But the bank is bound by what the RBI says. Therefore, unless the master circular, somebody comes to the court and says that, look here, this master circular 35A are all good myths. The myths to be busted, right? Somebody will have to come to the court and say, well, I am challenging this. And who is RBI to say in such matters and with an extended meaning which the attorney would like to give for 35A? Who is the RBI to come and say all this? So somebody will have to come and challenge 35A, the master circular, and say, the bank cannot choose its own investigating agency. But I cannot read 35A or the master circular in that way. It is not the bank choosing it. The bank must abide by the discipline of ensuring that the banking integrity of the country, proceeds on certain lines. We have seen a large number of bank frauds across the world. The Lehman Brothers, all of us know about that. Yeah. So therefore, if today we are marching into an area, a digital area, a technology area, a new way of committing crimes, where anything can happen and all things can be put under the carpet for good or bad reasons. So therefore, the master circular is not under challenge. 35A or the authority RBI is not under challenge. And I am not choosing my investigating agent. I am bound to go by that principle. These are two answers to that question. Yeah. So having said that, I was looking at their reply, not permitted to go to their objections. Yes.
Yes, sir.
I would like to draw attention to one more legislation, which is a later day realization by the Parliament of the importance of why CBI will be the investigating agency. This is the Banning of Unregulated Deposit Schemes Act 2019. That's right. So we had seen all kinds of deposit frauds from Sharda and onwards and small time Pondicherry. We have seen all over the country. So this section 30 of this act says, on receipt of information under section 29 or otherwise, if the competent authority has reason to believe that the offences relate to a deposit scheme or deposit schemes in which so-and-so takes property is involved and all that kind of thing, the competent authority shall refer the matter to the central government for investigation by the Central Bureau of Investigation.
Section 30 of the Butts Act.
That's right.
All right.
So if there is a mid-path card out here, it will refer to central government will then act and directly ask CBI to investigate. Another interesting provision here, as a follow-out, as a sequitur to Section 30, like subsection 2, the reference made by the competent authority under subsection 1 shall be deemed to be with the consent of the state government under Section 6. So even where the Section 6 DSP Act may have some relevance, this legislation says your consent is not to be given expressly, it shall be deemed to be available to the competent authority. So today we have marched forward on understanding how special classes of offences on public, having regard to public interest, will now be entrusted to CBI.
Yes, sir.
I looked into the details for the accused in the charge sheet. A very interesting narration about who are they. I'll just take a lordship through that, just broadly stating. Some of them are part of the officers of the Valmiki Corporation, and some are outsiders. And money has flown from money which belongs to the corporation has come into the Union Bank and flown out of the Union Bank and into so many hands. So it was very curious to understand how the money belonging to the corporation. And the bank has been used as a tool for getting into it and then making it flow out of it. And who are those people who are part of the conspiracy? Why are they involved? Why would a head of a corporation like this would be party to allowing its own money to get into somebody else's hands outside? Not certainly with good intentions for doing public interest work for the tribal advisory corporation. None of them have any connection with the tribe's development. So who are they? Why are they here at all? The answer will be given only by a proper investigation agency. All that the charge sheet says is money has been so-and-so, 50 lakh been given to so-and-so received 1 crore, etc. But why that money went into their hands? What is the reason behind that? For what purpose? I don't think the corporation, Valmiki Corporation, would like to share its bounty with some strangers outside for holy reasons. Therefore, it's a very important question. The charge sheet, therefore, would like to close it very quietly at this stage so that any further scan may not bring out certain unseemly things which might have happened in this case. And
the statement of objection,
yeah,
filed the charge.
part of the charge sheet.
Yeah, part of the sheet along with the state. They have filed it along with the state.
Very well. I think charge sheet is
Yeah, court records.
of course, if we are not today converting the court into a regulator of the investigating agency or a trial court in some disguised way, so that certain things are debated in the court and then dealt with, answered indirectly or directly. I don't want to get into the question, but I was only looking at very curiously at how the charge sheet handled this. As for a doubt arises, as to why the charge sheet would like to close it the way it would like to close it.
Yes.
That's broadly my response to the preliminary submissions. And
We'll hear the other side.
yes, sir.
And we'll answer the preliminary submissions and then get into.
Very well.
ಇವತ್ತೇ ಮಾಡ್ತೀರಾ?
Please, Madam,
If continuing?
if it is only on the preliminary point, my lord.
On the preliminary issues.
Yes.
I'll first decide about the preliminary issue.
Please,
Because you've given me a judgment saying that
Yes,
it should not,
My lord,
it's
if
not
it is not
maintainable here.
inconvenient to my friend, have it tomorrow or.
That's all right.
Tomorrow we discuss. Yeah.
No, it's, I am here. You can choose your date. I have no problem at all.
I don't want,
Since I've heard this, I'll post it for further hearing, whichever date you want.
or any day convenient to learn it.
And I understand that. I also want to see that the court's availability is also equally
No
important.
problem. Friday, Monday, anything.
Please.
Because I think we are here up to the first, from the second it is closed. For vacations. Second, Allah? First of all.
Any date?
Friday ಬೇರೆ ಇದೆ. ಯಾವ ದಿನ ಇದೆ?
I'm sorry, this calendar is always.
No problem. You take your time. Even if the learned ASG would inform the court, that would be fine. No issues.
It's convenient for the court. I think we can have it on 30th and conclude.
All right. Monday, yes.
Please,
No
please,
problem.
please.
I'll do one thing. On Monday, you answer on preliminary submission.
Please.
As also on the merit, we will decide it.
Please,
Yes.
please, ma'am.
That's it.
So that piecemeal won't be there, we'll close it on that day.
Fair enough.
Yes.
Yes, ma'am.
Heard the learned Attorney General, along with so-and-so, appearing for the petitioner, the learned Senior Counsel, B.V. Acharya. Now the special, how do I address?
Special public prosecutor is what the nomination is.
Special public prosecutor for the state government, learned Senior Counsel, Professor Ravi Kumar, representing the sixth respondent and all others. List the matter on 30th. What time? We'll take it at 2:30?
Even at the early part of the time.
Yes.
Whatever time would suit your lordship.
2:30 is fine?
Even I can come in the, I can come in the morning hours, no problem.
No
We'll have
problem.
it in the morning. Will be better.
All right. We'll
There
take
is
it
a
as,
spillover. There is a
all right, yes.
to the afternoon.
Remember, take it. Yes, 30th. 30th for the hearing.
Grateful.
Public.
ಅಲ್ಲಿ ಬ್ರಾಕೆಟ್ ಅಲ್ಲಿ ಬ್ರಾಕೆಟ್ ಎಸ್ ಸರ್ ಗಿವ್ ಇಟ್ ಗಿವ್ ಅದೆಲ್ಲ ಪ್ಲೀಡಿಂಗ್ ಜಡ್ಮೆಂಟ್ಸ್ ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ ಐ ವಿಲ್ ಜಸ್ಟ್ ಗೋ ಥ್ರೂ ದೆಮ್
Yes.
ಎವ್ರಿಥಿಂಗ್ ಎಸ್ Entry in the list. Omkar. 12. Huh? Stay ಆಯ್ತು ಸರ್ ನೀವು ಇರ್ಬೇಕಾಗಿಲ್ಲ ಸ್ಟೇ ಕೊಡೋ ಕೇಸ್ ಇದ್ರೆ ನೀವು ಇಲ್ಲದೆ ಇರೋ ಕೊಡ್ತೀನಿ ಎಸ್ ಸರ್ 12 CC 2017 Omkar.
It is a false allegation where the complaint has been filed
False
after
allegation ಇರ್ಲಿ.
a week of 7
ಇವತ್ತು
days, the
ಏನ್
complaint has
ಸ್ಟೇಜ್
been filed,
ಯಾವ
my lord.
ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ವಾಟ್ ಇಸ್ ದ ಸ್ಟೇಜ್ ಟುಡೇ
It is in the evidence stage, my lord. It's a 2017 matter, evidence stage.
No,
ಮುಗ್ದಿಲ್ಲ.
evidence stage ಅಂದ್ರೆ ಅದಲ್ಲ. If charges are framed and trial is commenced, I will not interfere. Sir.
ಅಲ್ಲ, it is still in the stage of evidence. Only the documents
In
have
the
been
stage of
filed.
evidence ಅಂದ್ರೆ trial is commenced.
7 years delay ಇದೆ already. Complaint file ಆಗಿದೆ. There is 7 days delay in filing of the complaint.
7 days.
Please.
Not fatal.
15/11 is the incident.
Damage to public property is there. Sir. ನೋಡಿಲ್ವಾ file?
They are not the party. Copies are not.
Why you are the party, sir?
Copies have not served to us.
Damage to public property ಅಂದ್ರೆ ಸ್ಟೇಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ?
Copies have not served to us.
ಗ್ರಾಮ ಪಂಚಾಯತ್ is the complainant.
Copy is not served. Copy is.
First respondent ನೀವೇ. Copy serve ಮಾಡಿ.
Please.
Counsel for the petitioner to serve set of papers upon the counsel with the respondent list on 15th October in fresh matters list.
Good.
Yes. Arrears ಎಷ್ಟಿದೆ ವಿನಾಯಕ್? Where is Vinayak?
Petition.